back in session, the hearing. I think the appellant is going to give us a presentation at this time. You're up.
Thank you, Mr. Chair. Nice seeing you all again. Actually, just to take you back in history a little bit, if you remember, I appeared before you on August 8th, and I was pleasantly surprised. Okay. You may just need to sit down. Okay. Is
You
it
can lift it up and
May I have permission to sit during this presentation?
absolutely.
Thank you. All right, so on August 8th, I was here, and you graciously allowed us to go back to the Planning Commission. And I told you at that time I didn't expect to be back, and I'm sorry that I have to be back. But the Planning Commission didn't agree with our position, so here I am. It's interesting that they always say a picture is worth 1,000 words, but pictures also tell two sides of stories. So although you saw some photographs here today, I'm going to use the same photographs and show you that it's just that the Planning Commission and the Planning Director and I are coming from a different viewpoint. And we're not going to be talking about cultivation. We're really talking about earth moving, which is the other plank of N3, if you remember. So I'll just start the presentation by noting that the correct applicant here is Cali Farms Patient Collective. Stuart Alberts is simply an officer. And so to the extent that that was incorrect in the record, let's just make sure the record's correct on that. And the purpose of this deck is really just to highlight the grounds for appeal. I have given you twice now, once back on August 8th, and then this morning, and I apologize for the late delivery, but as I'm getting older, I'm forgetting about national holidays because where I work, we don't get the day off. And so I was here yesterday at 11 o'clock in the morning only to remind myself that you folks fortunately get the day off and I don't. So, but what I gave you this morning is almost, with two exceptions, 90% of it's the same as what I gave you back in August of last year. I also gave you a copy of this slide deck in case it's easier for you to follow on your own than follow up here. However is best for you is fine, but I wanted you to have the slide deck for future reference and also to put it into the record other than by video. The slide deck is an excerpt of the full papers. The full papers speak for themselves and they're incorporated by reference. We already discussed the recusal issue, so that's off the table. I do have a question, though. Every other time we've appeared, the notices of the hearing appeared in the Calaveras Enterprise, which, as I understand it, is the publication of general circulation in the county. And this is really more of a question. I'm not raising. This time, I noticed that the publication was only in the Valley Springs News. And when I look at the Valley Springs, and I had to find it because I couldn't find it. And when I looked at the Valley Springs News, I see that they only claim that they service 4 communities within the county. So I wonder, I know the board designated this periodical as the official one, but is it in fact a newspaper of general circulation?
Yes, please.
Yes, you are correct that we now going on about 3 years ago, the county went out to RFP for basically the paper to provide required legal service. At the time, the enterprise did not respond timely to the RFP request, which was really the primary reason that...
3 years ago? I'm sorry, did you say 3 years ago?
Yeah, it was approximately 3 years ago, I believe. 2.5. Actually, I guess it was 2.5 years ago. Because we're coming up at the end of this June as kind of the sunset of that, and the intent is to go back out to RFP again. But the reason that Valley Springs is used is that we did go out to RFP on it, and the enterprise was not responsive at that point.
Well, my point, Mr. Lutz, was that even in the last 6 months, all of the hearings, including the hearings on our bill, have been published in the Calaveras Enterprise. This is the first time.
And unfortunately, that's coincidental. What happened is, and it's, it is interesting timing. when the full text of the recent ban went to the enterprise, they contacted us and said, hey, we've been doing this free of charge, which they have been. They've been doing it as a basically a public service. But it hasn't been, they don't have a contract with the county to publish it. They were doing it on their own volition.
So they wanted to charge you for it. Interesting.
Yes.
Okay, I'll just note that the county code at 1798-070, I believe, requires publication in a newspaper of general circulation. I've had this issue come up in other counties. I'm not really sure this is a newspaper of general circulation, but I'm just mentioning it because I was surprised that I couldn't find the notice. And, so if it's supposed to be a public notice and people don't know where to look for it, it's not really a public notice. Megan?
Just for clarification for the record, is that when the contract went out, the board at the time found that the Valley Springs News was a publication of general circulation and that it met the requirements for legal noticing, and that is why the county entered into a contract with Valley Springs News back approximately 3 years ago. So the board has certainly found that the Valley Springs News is a publication of general circulation within this community.
Okay, it's a new one on me, and I'm just,
Chair, I
Not
might make
sure.
a note. The only paper that is distributed via a box in Vallecito is the Valley Springs News.
okay, fair enough. Just noted that I couldn't find it until yesterday, so. All right, so we're really here for two reasons. The first is we have an appeal, obviously, on 2016-629 of the denial of the cannabis application that was made way back on June 26th, 2016. The second is not really an appeal. I wanted to point out to you that on the same day that the denial letter was issued here by the Planning Director's Office, May 15th, 2017, the Planning Director also, and I believe erroneously, sent a tax assessment letter. I'm going to get to this later, and this is just,
Planning director does not send out the tax notice.
whoever sent out the tax letter, it came from
That
the
would
same
be-
office.
That would be Barbara Sullivan,
I don't
tax
think,
collector.
is that what the exhibit shows?
Yes.
Okay, I'm just pointing out that on the same day that a denial is issued, a tax assessment is issued. So I'm going to
Coincidental,
get to
I'm
this
sure.
later, pointing out that I'm going to make a little presentation on this, even though it's not technically an appeal at this point. All right, so the first thing I want to raise is you heard Miguel say that after the first time we were here on August 8th, the planning director issued 2 days later, on August 10th of 2017, what they called an additional ground for denial. And I'm going to get to substance of it later. I just want to point out one thing. The ground for denial, it's an exhibit in your package, said that they discovered, based upon new information, which were photographs that you saw, that they put up that were dated June 2nd and June 28th, 2017, that apparently, I would describe it that the canopy size looks like it moved or increased. What the letter actually said was that there was new information that an area was graded somewhere between June 9th, 2016 and August 20th, 2016. And they added a second ground for denial. Now, this under N7. As a procedural matter, this matter was on appeal as of May 30th, 2017. I've never been party to an administrative process where once something is in appeal, where the grounds for the original claim can be changed. I think the appropriate thing for the planning director to have done here would have been either to quash the original denial and issue a new denial with all of the grounds for denial, as they do in all of the cases, or this really was an after event. This was a year later. There were no plants on the site in 2016. They never got around to it. On 2017, they did plant. I'll show you later that it is not what they claimed. But the appropriate thing to have done would have been what you heard in the last appeal, number 6 on your calendar today, which was if they believed that the canopy had been increased or that the plants were in the wrong place, to issue a notice of abatement. not a notice of denial. So I'm saying as a procedural matter, I don't really think you can change the scope of the grounds for denial after something is in appeal. Now, while it's pending, I think the planning director has full authority to change the grounds. But once it's an appeal, an appeal's an appeal, and the record is what the appeal is. So I'll get to the substance of it later. I'm just saying this was not correct procedurally, and it should have been done differently. So let's get to this just gives you a little bit of the case history. This has been around for a long time, as you all know. It's been up to the Planning Commission twice. And here we are almost a year and 2 months later. So this is in your papers too. I just wanted to give you a little idea. So let's get to the meat. We've given you a number of grounds for appeal. I'm not going to be discussing all of them. I'm preserving them all. The only two I'm going to be discussing today are the 165N3 and the so-called new grounds. And we'll make it short. Okay, so history is on June 26th, 2016. Cali Farms applied for a 10,000 square foot canopy license on APN 021, 020, and 005. The application was originally denied solely because of the lack of photographic evidence. Now, you saw the photograph that Mr. Contreras put up on the screen, which Mr. Alberts, who's the officer of Cali Farms, attached to the application. It was clearly the wrong photograph. He admits it in his declaration. In fact, he showed you another picture of the adjacent site where that photograph came from. He filed 2 appeals on the same day. He was here in the room. He got the picture mixed up. He put it on the wrong application. This one didn't have a picture. I just wanted to clear the record up. That picture was never intended to be attached to the application. It did not apply to the site, and it was withdrawn in the first set of papers that we rendered. He admits it was an error. It was just an error. Now, the thing that I wanted to bring up about it is, and I'm not faulting anybody, but this material was in. Obviously, the planning director was able to see this very clearly when they reviewed the application. And I think that it would have been far easier and better and more procedurally correct to have gotten in contact with Mr. Alberts and asked him whether or not he had a different photograph that he wanted to offer, because this wasn't inadvertent. He didn't know about this until the staff report came out for the first denial. So let's look at N3 for a minute, because there's 2 very important points here that I want to make when we get to the photographs. I've highlighted the language. There's nothing actually in N3 that requires photographic evidence to be date stamped on or before May 10th. The actual ordinance simply says that there has to be evidence satisfactory to the planning director that on or before May 10th, the applicant had taken demonstrable steps to do one of 2 things, either to cultivate, which is not in contention here today, or to grade or earth move. But there's actually nothing that says that the photograph has to be dated that date. It's just that the planning director has to make a determination based upon all of the evidence that on or before May 10th this occurred. And that's what's at issue here today. The second, and I point this out, is that the 2 standards in the first highlighted area are that there has to be evidence of grading and or earth moving. It's either one. And there's a difference between the 2. Grading is leveling. Grading is actually when you prepare a surface to be level. Earth moving is just moving dirt. Now, the draftspeople of this ordinance contemplated that a preparation of a garden was what was at issue. You could do one or the other. You could move dirt around to demonstrate it, or you could grade. Now, I know there are areas in the county that are steeply sloped, and the only way that you could actually prepare something is to terrace them or somehow grade, and that is true. This is not the case on this site. This is a flat site. The area chosen was deliberate because it was flat. It doesn't need any grading, and no grading was performed. Earth moving, however, was performed. Now, in the papers that the planning director gave you, the planning director cited to another section of the county code for the proposition that there is a defined term grading. And that simply is just not applicable here. These were lowercase terms, grading, earth moving. They weren't capitalized. If they were capitalized, there would either be a definition in the definition section of the ordinance, which there is not, or it could have been done by cross-reference. For example, the definition of cultivation in the urgency ordinance. There is no definition. It says that the definition that applies is the one under the California Professions Code. So they know when they want to incorporate a definition from another place, they know how to do it. Here they did not. So you can't rely on a definition that's not there to support this. Statutory rules of construction are that when words are used in lowercase fashion, they are designed to be determined in their ordinary meaning. And I've just shown you what the ordinary meanings are. You can look at the sources on these. All right? Now, it's either grading or earth moving. We are not claiming that Cali Farms performed any grading at all on this property. In fact, we would deny it. There was earth moved, however. Now, I am actually the representative of property owner. I hired Charles Larson, a man that I did not know, never had any contact with, to perform work to get the site prepped for Cali Farms, which is simply a tenant on the property under release. Mr. Larson gives you a declaration, which is in your packet. I've highlighted the paragraph 6 and 7, in which he says that starting in April, he started to do some work clearing the site, that he first cleared up an access road, because if you remember from the photograph that Mr. Contreras put up, the access to parcel 005 is actually on 006, so there needed to be a little spur. He said that by the end of April, the 300-foot access road was cut, and I began the field scraping. The process lasted through May 5th, 2016. The scraping part of the work was completed fairly quickly for the 150-foot by 75-foot area. So here's the photo. This is in the county package, actually, that was taken May 1st, 2016, off TerraServer. And you can see that I've highlighted for you the proposed cultivation area in yellow. And in red, I show you the reclaimed access road. So this was the road going to, you see the 006 has the house on it with the little pond. You see the street over there, that's Oak Ridge Road. You see the driveway coming up. That is what he worked on up until the end of April. There was all grass there. I have the pointer, actually. Oh, I brought the pointer. So this was the little road. All right, it's part of the driveway, but there was no driveway here. This driveway was completely grassed over. Mr. Collard, who owned this property since 1980, hadn't used the property in 10 years. He passed away in January 2016. Ms. Colleen Downing inherited the property, and that's when this whole activity started, because she decided that she wanted to explore cannabis cultivation. So this is the work he did up until May 1st. And you can see that this is from his declaration. Now here's the picture that you saw Mr. Contreras offer you. And let me show you what it depicts. So this picture is from May 31st. So one thing we know right away is that somewhere between May 1st and May 31st, this whole area was done. This whole access road coming off the road that I showed you in the prior picture. And now we have this leading up to this. So all of this was done with earth-moving equipment. This is still, it's a fairly flat section, this whole section. There are a few trees and shrubs, but it's mostly grass. He didn't have much work to do. He really had to remove it to the surface, just scrape it off, and clear it. Now, as it turns out, there was never any planting done on this property. All of the plants were put on pallets in smart pots. So actually, there was no reason to go underground. And the pump that serves this area is actually right on the corner over here. I'll show you that in another picture. So Mr. Larson tells you that he did the work between May 1st and May 5th, before May 10th. This photograph shows you that by May 31st, there's no question that that work was done. Now, the dispute one of the disputes that the planning director's office identifies, which I think Mr. Contreras stated clearly, is that in their view, this was just somebody driving on the property with a four-wheel truck or something or other mowing down grass. But Mr. Larson, who's a licensed business guy in this county and has been so for 30 years, tells you in his sworn statement that he actually scraped off all of the underbrush there and cleared that area. This area that I've identified is the 10,000 square foot area. Somewhere in the county director's staff report, they claim that there was an 18,000 that this whole area was 18,000 square feet. This area measured out is actually 43,456 square feet. That's an acre, a little more than an acre. It is now fenced. The green line represents the fence. That is the acre. This was the only little cultivation site. So at this point, I will say that if you accept that my interpretation or my reading of N3 allows the planning director, or actually requires the planning director, to find that if demonstrable steps were taken and it could be shown that on or before May 10th, an area was cleared out commensurate with the size of the intended canopy by earth moving, then what you have here is a combination of a photograph, which is contemporaneous with May 10th, and somebody's who did the work signed declaration that says that the work was performed by May 5th. Now, I'll point out to you that no one from the county, as far as I know, has ever been out to the property. All of the information that you get is from satellite imagery, which is taken from 22,000 square feet, whereas site visits really would demonstrate what we're talking about. And, eyewitness testimony is always much better than imagery. And you heard a lot of discussion here today about GIS and about its limitations. So Google itself, Google Earth, which is one of the GIS, will tell you, and you can check the source on this, that for accuracy of measurements, and this includes, if you remember, Mr. Contreras stated that he thinks that area that I showed you in the prior pictures, this was only 2,400 square feet, and measured out, it's actually 11,250 square feet. This whole area is 43,000 square feet, not 18,000 square feet. And why is that? Because even Google will tell you that we make no claims as to the accuracy of the coordinates in Google Earth. These are provided for entertainment only and should not be used for any navigation or other purpose requiring accuracy whatsoever. The best you can do is find something of known distance near your feature and see what it measures out to estimate the error in that area. So what this means is that there's no scientific value to Google Earth. You try to introduce this stuff in a court of law, it's going to be thrown out. No one can testify to it. You have to take on-site measurements. So I'm just pointing out that the discrepancy is because we're using actual measurements and the planning director is using satellite imagery. And I think as you've seen in many of your other appeals, and including the one this morning, the accuracy level of this could be off by 50 feet in one direction or another. Clearly the dimensions are not accurate at all, and they don't claim that they're accurate. Now here's the aerial image that you saw before that Mr. Contreras gave you from June 9th. Now, what he stated about this was, we never saw any evidence of cultivation. But the ordinance does not require that you actually plant anything. In fact, it doesn't require that you ever plant anything. You can elect to have a license and simply decide to put it in abeyance. That's the grower's problem. I mean, if they don't want to grow, what actually happened here is that Mr. Alberts and his team put some plants on the property in 2016. They succumbed to a fungus, and there was never any harvest. So it was very short-lived. And yes, by June, nothing was there because they didn't start until later. I don't even know that they would have gotten a harvest in anyway. But there was no grow in 2016. But that's not a requirement under the ordinance. The ordinance doesn't say you have to have plants on the property. You either have to show cultivation, that's one, or show earth moving. We never claimed that there was any cultivation here. It started in 2017. So here we are. I'm just showing you the same photograph that they used. Yes, it's clear there's no cultivation there, but look at the area of the cultivation site. That is really something more than some guy with a four-wheel truck. And the only way you'd know that, by the way, is someone from the county coming out and taking issue with Mr. Larson, who did the work. Here's the same photo. I bring it up only because you see that I actually asked Mr. Larson later on in the year, before we put the fence up, as a requirement of the ordinance, to scrape off dirt in the remainder of the area so that we could use it for other purposes. I intended to put some ornamental greenhouses on there, store some equipment, tool shed, etc. While he was out there, I had him do the work. That's all that shows. But you'll see that the planning director cites this activity in part for the second ground for denial, which I'll get to later, which has nothing to do with cultivation. So on the question of whether or not the application should be granted in the first instance based upon compliance with N3, I submit to you that there is ample evidence, using date-stamped photography, by the way, and using the declaration of Charles Larson, the guy that did the work, that there was a cultivation site prepared, earth was moved, slightly greater than 10,000 square feet before May 10th. That's the only standard in the ordinance. Now, let's get to the second ground. And this one, as I say, procedurally, I think they did this the wrong way. But substantively, I don't know that it's going to matter that much. So what the planning director cites is N7 for the proposition that if you expand an area in which there is a cultivation site, that automatically that somehow constitutes a violation of N7. But actually, the only part of it that's fatal is if you're actually expanding it for the purpose of using it for cultivation, not if you simply do what we did, which was to clear the area out so that it could be fenced. I've highlighted the language for you. He is correct. As of May 10th, all grading and earth moving in the portion of the parcel to be used for cultivation shall be complete. You could clear 4 acres. You can clear 10 acres. There's nothing in N7 that says you can't do that. You just can't. So this was put in there to prevent you from starting an earth-moving operation, clearing out half of the intended cultivation site, and then coming back after May 10th and completing the work. It's not to prevent you from clearing the rest of your property. You can do that. He also relies on the last sentence, no additional grading or earth moving for this purpose of establishing or expanding a commercial cannabis cultivation site shall be permitted after May 10th. Again, we have grading or earth moving, okay? Yes, if more earth was moved here, or if grading was done for the purpose of establishing or expanding a cannabis cultivation site, I would agree that something was wrong here, but that's not what was done. Let's take a look at the photographs. All right, so first, as I stated, the only earth movement after May 5th, 2016 was to clear out the area outside the cultivation area, and I'll show you the photographs in a minute. No expansion, and the county photographs do not support the denial. So here is the photograph that Mr. Contreras showed you from June 2nd, 2017. This is what he showed you. Now here, I've highlighted for you the cultivation site. I blew it up best I could. There are the plants. They're all within that area as of June 2nd. Now fast forward to June 28th, and this is the one he showed you. Here we have the cultivation area, and there's no question there were plants outside. These plants were on pallets. The pump that services this area is located right there. You can see the solar panels. That's the little black square. Pump's right underneath them. This pump broke somewhere after June 2nd. I hired a contractor, PumpGo, out of San Andreas to come and repair it. This road is the only way they can get up there. And so I asked Cali Farms to move the plants from this area here and this area here over to here temporarily so that the truck could get up here. It's a huge truck. They had to lift the pump out of the ground. It's 760 feet deep. So they had to bring the big piece of equipment in 25-foot sections at a time. They had to lift it and take it out. Shortly after June 28th, these plants were put back. They are no longer there. Now, if the planning director had simply issued a notice of abatement, which is what they did in the last appeal that you heard, those plants would have been moved very timely and put back. Instead, he uses it as grounds that the cultivation area was expanded. And in fact, there was no expansion. These plants were simply over here, and they were moved over here temporarily. Okay, now, I just want to raise this because the decision you make today...
Mr. Firmer, I would just like to clarify. It's my understanding that you're going to be going into the canopy tax and the issue of the canopy tax. And it's my understanding that nothing related to Measure C or the tax was brought up at any of the prior appeal hearings. And I just want to make sure that the record is clear that according to our procedures, the
No new evidence.
all issues have to be presented at one of the prior appeal hearings. If that hasn't occurred, any new evidence, it's in the discretion of the board to receive it, and it is in the board's discretion to remand it back to the Planning Commission if they deem that the information rises to the level that they would have to have the Planning Commission consider it. So just for clarification purposes, this is new information that has not been brought up, nor has it been presented to the Planning Commission in prior hearings.
I appreciate that, counsel, and thank you. I'm not here to appeal it.
Chair, I have a point of order on that as well. There's an appeal process for the assessment of taxes. It's on the face of the exhibit he provided. You can make an appeal to the CAO's office, which can then be appealed to the Administrative Hearing Office. And that appeal was not undertaken, and there's no reason that that should be litigated here today.
And I'm not proposing to litigate it. I simply want to.
Yeah, I want to poll the board first to find out if they want to go forward with this, how they feel about it or what. Supervisor Mills?
I would just soon not go forward with this
Supervisor
discussion.
Oliveira?
I would concur with Supervisor Mills and not address this issue at this time.
Supervisor Garamendi?
I don't think it's germane to the issue.
I'm in agreement with the other three, excuse me. That makes 4 of us, so we will not hear this evidence.
Fine, then I'm through with my presentation. Do you need to plug back in?
That concludes your initial presentation?
Yes, sir.
Okay. We will go to public. Is there any public comments?
I'll go back to the station over there to say that's
No public comments? We'll go to staff summation and rebuttal.
So Mr. Firmer has alleged that his client, Kelly Farms, moved earth prior to May 10th, 2016 in order to establish a cannabis cultivation area. And he showed pictures of grading and a declaration by the grading contractor that he had done work on this site prior to May 10th. Mr. Larson, I believe the contractor's name was, stated that he had scraped it down to bare a couple of inches into the ground for the road, as well as scraped the vegetation away. I don't remember the exact language that was in the declaration. But this photograph, which was taken on, aerial image taken on May 31st, does not show down to bare earth. It shows some tracks, whether they're tire tracks or tractor tread, but there's certainly no evidence of any scraping of earth, any earth movement having been done. It's just simply they've driven across what's now appeared to be dry grass. And so we do not believe that there is any evidence whatsoever of earth movement having taken place. With regard to the suggestion that I contact the applicant and say, hey, the photograph that you submitted doesn't reflect what was on the property. Do you have anything more you can give me? It was the responsibility of the registrant to submit proper information at the time. There wasn't any, and it's not my responsibility to go track down 740 different registrants when I didn't have the information. Some people were very clear in their information they gave to us, others were not, and this was simply one that just did not show any evidence whatsoever, and the only evidence that they purported to show for cultivation or preparation of the site, earth movement, was the one photograph showing the adjacent parcels. We did not feel it was necessary for us to reach out to the registrant and say, hey, do you have any more information? It seemed clear to us that this was just simply false information. finally, with the idea that we added a new ground for denial during the appeal process. Procedurally, that may not be the most appropriate course of action. The alternative would be to sort of start the process over again. And maybe that's what was the desire of the appellant to, sort of start the clock over again on this. But rather than, the alternative would be to have the registration denial appeal granted by the Planning Commission referred back to us, and then we denied again on a second reason. This sort of consolidate the process, let the appellant know, without having to refile an appeal, that here are other reasons, and it, in our opinion, simplified the process and expedited the process for both the county and the appellant. We are inundated with applications and appeals, and we thought this was just a way to expedite the process when we identified, because we had received new aerial imaging that clearly showed that grading had occurred after May 10th for the purpose of cultivation. There was a much larger area of grading that occurred. Granted, there weren't plants on that, but this whole area is a cultivation area. And the grading occurred. If they'd only graded just the footprint of the plants, they probably couldn't have utilized that space because they need area to get around it. So for us, this grading was for the purpose of cultivation, and clearly was in violation of the requirement that grading had to have been done prior to May 10, 2016. If you compare that with the May 31st photograph, grading occurred much later than that fact. And whether, as contended that it was going to be used for some other storage, cultivation occurred in that graded area. So grading did occur, and it was in violation of Section N7 of the code.
Now we're going to have summation and rebuttal by appellant.
Chair, if you don't mind, I have
Okay, if we're not done, staff, let's finish.
With reference to the adding of a new basis for denial, Peter hit on the reasons why that's sound public policy, because if an appellant were to prevail at their hearings, it would simply go back to Peter for further processing, and then the process would be started over again for denial. Additionally, because the appellant is provided with notice of the additional basis and is afforded an opportunity to be heard, there's no due process issue implicated, and as indicated by Peter, it's just sound public policy.
Thank you. Anything else? Okay. Appellant.
Thank you, sir. All right, so first, I'll only say this, that where you have two different contrary views about what something represents, and one is not based upon any eyewitness view and is taken from 22,000 feet, and you have another one that is based upon eyewitness on-the-ground view, you really can't give a lot of weight to a 22,000 foot. What are we asking here? We're asking if the guy who does the work says that he scraped to 2 or 3 inches below the surface to prepare the area, he had to have moved dirt. Now, I appreciate that the planning director, looking with his, obviously 20/20 vision from 22,000 feet, could have a different view of it. But it's not the same as if somebody had come out and said that that is just not true. So you have to weigh the difference between someone with an on-site, on-the-ground, telling you what he did, and somebody looking at it from 22,000 feet. And so we can disagree. There's no disagreement over that something happened there. It's just that the planning director's view is that that's not what happened. And by the way, these little marks, which you see, I'm going to highlight them. So obviously this is where the guy turned around, but that is not in the area that I identified before for you, okay? Secondly, the proposition that an entire area which is cleared becomes a cultivation area if it's not intended to be used for cultivation or wasn't used for cultivation is just patently wrong. I should be able to take this entire area, if I want to, and clear it of underbrush, plant anything else I want over there. That does not automatically, because it's adjacent to this, become part of the cultivation area. The cultivation area is a defined term in the ordinance, which is the place at which the plants are put. You can put equipment someplace else. It doesn't include tertiary buildings. It doesn't include storage. It wouldn't include, if I kept hoses and other things like that. No, this is the place where the plants go. And virtually everybody has some other area of the property that they keep the heavy equipment on. So what we're talking about here is the cultivation area. There's a distinction between the cultivation area and the surrounding area. And so that's the second question. Now the third, on the new denial. Again, the difference between, and I thank the planning director for clarifying that, yes, public policy may be that you shortcut things. But let's face it, the IRS doesn't get to audit your tax return twice in a year. If they send you a determination letter and it's in court, they don't get to add new grounds. In fact, they don't get to, if the appeals people or the court agrees with you, that year is closed. They don't get to come back and keep taking another bite out of the apple. This process would be ridiculous if applicants either get registered and then the planning director comes back later on and says, oh, we got new evidence of something else, and you keep opening it back up again. That's where the notices of abatement come in. But we're talking about adding counts to a denial, and I've seen these letters. They check off every box that's a possible grounds for denial. Here there was only 2. And then all of a sudden, after it came to the board remanded it to the Planning Commission, did they get another one? Now, procedurally, I think we can agree that it wasn't done right. Public policy, fine, maybe good public policy. On the substance, which is really what I'm focusing on here, what I showed you was that the plants were in the cultivation area on June 2nd. They were temporarily moved outside that cultivation area on June 28th for the purpose of repairing the pump, which, by the way, in this photograph is right there. And then they were put back. Now, if in fact the public policy would have been issue a notice of abatement, we would have been able to demonstrate that that had been achieved within a short period of time, probably within days. But the planning director chose to make it an issue for the Planning Commission. And so that's how we had to attack it. And in fact, it was abated anyway. Any questions?
Supervisor Garamendi.
Thank you very much. Mr. Frimmer, excuse me, Peter, the area outlined in red on the plot plan for the application, is that the location? This is the location on the plot plan that the application had for the grow?
That's the area where the 2017, June 2017 aerial image showed cannabis plants.
When they turn in their plot plan for their application, is that the same location?
No, it's not.
Yes, it is.
Okay, so where is it on this? Sorry. Okay, up top.
So here's the road going to the house. Here's the access road. Now it was shown, remember this plant, it was shown this way. It should have been shown that way, but it was, generalized area. And that's exactly where it is. Here's the pump. You see the
Can you go back to the Google Earth image, please? No, the one with the grow on it. Oh, keep going. Where's the one that you had with, next one? That one. So, Mr. Frimmer, are you alleging that this image is false?
No. Peter, can you go back to the last one? Okay, so look, Supervisor, what I'm saying is, here, this is the area that was depicted. Here's the pump, you can see it.
Right.
So the area that we showed in the other photo, which is, now this doesn't show you the plot plan, obviously. This is a blown up section of 1 acre of a 40-acre site.
I understand.
Okay? So what you saw in the plot plan, here's the road, here was the area. Now, it was drawn this way instead of this way, but the clearing area is right here, okay? It's these 3 rows that were moved. From here, closer to the pump, back here, they're on pallets. So all they had to do was bring a front-end loader in. It took no time at all. They moved them temporarily from this area here, where they would have been within the area, to over here, and they were moved promptly back again once the pump was fixed. This is the only access.
Can you go back to that other image? Okay, so you're telling me that at the date of this thing, the plants were there and then they were moved. Is that what you're saying?
Plants were all in this area here,
And they were moved.
and these plants were moved partially from over here to over here.
I got to tell you, I don't see any evidence of dirt moving there. And if you're moving that many plants, there'd be a lot more crushed grass.
No, this picture was taken a year before the plants were actually there, Supervisor. These pictures are a year apart. Peter, could you move to the other picture?
May 31st, 2016 here.
See, this is a year later.
What's the
Okay.
next one?
These plants were moved from here to here.
I was back on the other image. I'm trying to find some evidence of cultivation.
You don't need
or siting, and I know you've got a different definition of it.
no cultivation, Supervisor. Cultivation is not what we're basing it on here. You don't need, under the ordinance, to actually have any cultivation. It's either or. You either show cultivation or earth movement.
Okay, well, I don't see either.
This is the area where the earth was moved. This is what Mr. Larson
So you're
did.
telling me that that is moved earth?
Not this,
No, this right here.
this. Well, he dug 3 inches under the surface. Now, this could be brush that he left there. He didn't have a blower.
You know, I was really looking forward to this because I went back and watched our video of August 8th, and I think I said, "Do you sincerely believe?" And your comment was, "You don't. You know, we won't be back here again, and you'll convince the Planning Commission." And it's a slam dunk. And I'm looking for that silver bullet you promised me.
I commissioned this work. The man did the work as we told him to do it. And I have every confidence that Larson did what he said he was going to do. Mr. Alberts told me you have Mr. Alberts' declaration that says that he did what he was going to do, and that this was all intended to be done before the May 10th date. But let me just say this. You know, the May 10th issue is, total coincidence. Photographic evidence had never been required in any draft of the ordinance that was presented for public comment or otherwise prior to the urgency ordinance. Every prior one required either nothing or 2 affidavits from third parties. No one would have known to take actual photographs because the ordinance was passed without, as you know, as an urgency ordinance without public notice and hearing. This whole concept of photographic evidence was put in at the last second. Nobody knew about it. I doubt very much whether you're going to see anybody with good photographs that they took in the early part of in the last month or two of 2016. They would have had to have the crystal ball that something or inside information about what was going on in the planning department. But I can only tell you that I have every confidence that this is what they say it is. I wouldn't be here. I'm not a guy who does frivolous litigation. I didn't fly 300 miles up here for nothing. And the difference that we have is that the planning director is looking at this from 22,000 feet, as you are. And I can understand, maybe from 22,000 feet, it doesn't show it as clearly as it should. But when the guy on the ground is telling you what he did, you have to give weight to that. And that's all I'm asking you to do.
Supervisor Mills?
Yes. I know, Peter, you had mentioned something about the picture being wrong on the application. Can you give me some idea when that picture was withdrawn?
I believe it was withdrawn at the Planning Commission hearing. Is that correct?
I withdrew it after we submitted the material to the Planning Commission. I reviewed everything, and I realized that that really wasn't probative of anything, and we didn't want to waste the board's time or the Planning Commissioner's time
Okay.
with it.
In your comments, you said something about the road coming in, and you also said something about a few inches of dirt being moved to scrape the area. I'm just going to
Finish it.
roughly say, you know, if you're looking at a 10-foot wide road and 400 feet long, you're at about 26 cubic yards, just a couple of inches. If you're looking at your 10,000 square foot pad, that's not the area outside of the pad. You're at 31 cubic yards on that. My question is, did anybody get a grading permit?
I asked Mr. Larson 3 times whether he moved anything that would require a grading permit. He's been in this county and done work for 26, 28 years, and he said no. You can see that now, earth movement, by the way, in the ordinance has no boundaries. There's no minimum and there's no maximum.
But earth movement within Calaveras County Code does have boundaries.
But point is, within the ordinance, all we're asking for is any earth movement. It doesn't have to be 5 cubic yards, 500 cubic yards, 5,000 cubic yards. It simply says earth movement. It doesn't say of a minimum amount or whatever,
Okay?
okay? And
Next question is, you had said something about removing a few trees.
oh,
Would
Well,
that be,
let's see.
that would be this tree?
no, they were over here, actually. I think these were removed.
Well,
Yeah.
I've got all of those trees here missing.
These, well, those might have been removed too. Yeah.
Well, do you believe under PR 4571A that you might be involved in some type of land conversion?
No? 2 trees?
Well, yes, but you're converting land that has trees on it to land that has no trees on it. Was CAL FIRE ever notified?
No.
Okay.
It was done by a licensed tree removal guy.
You said
I
something
don't know that
about
that's, I
do
don't
you have
know.
a pump there?
Sorry?
There's a pump on this side up in
Yeah,
here?
you can see it in the other, Peter, could you?
So
the
did
other
they
picture.
drill a well there? Was there a well
The
there?
well's been there for 30 years.
So there was a well there, they
Yes.
just took advantage of it?
Correct.
Okay, thank you for now.
Any other board questions? If not, we'll kick it back out to public. Any public comments? Seeing none, we'll bring it back. Is there any more board questions?
Mr. Chair, I'm not sure if it's within the scope of the parameters, but Mr. Frimmer made a statement about there is no qualifications for earth movement. And the section of the ordinance is actually, it says, earth movement commensurate with the area to be cultivated. So we would need to have seen 10,000 square feet of earth movement, you know, the area commensurate with that size of a cultivation area. So there are parameters. Just want to clarify.
There are parameters. I have a couple. Supervisor Olivera, your light's on.
I'm going to reserve my comments to after I hear yours, Supervisor Tofinelli, because I'm kind of on the same subject that I think you're going to inquire about.
Well,
Go ahead.
can you go back to the previous picture? That one there, the one that we keep flipping back and forth from. And everybody's concentrating on this area right here. I, on the other hand, am reading the documentation that was presented to us. And it says that on behalf of WEC, I was contacted with Mr. Larson to cut an access road to the field from the existing driveway at 8535 parcel, and to scrape the grass and small brushes off a portion of the area of the field about 150 feet by 75 feet wide at the end of the access road. He also says Mr. Larson performed the work in mid-April through the end of the month and into early May. I was informed that most of the work was completed by May 5th, 2016. May 5th, 2016. And Larson, who was very busy at the time, came back later in May to put a rock down on the access portion of the road. Well, I'm looking at this, and this is May 31st, 2016. This picture right here, is that correct?
Correct.
I'm looking at this access road, and I'm looking right down the center of it, and I'm seeing brush. I'm seeing all kinds of growth. I'm seeing nothing but heavy brush in this area right here leading up to that. Can we go to the next picture that was taken on June 2nd? That's all been removed. That's wider. That's been cut in. That's been graded. That's been going in and out there. So all of that work was done after May 31st, 2016, not before. All this area here has been scraped or graded out versus the other picture. So I'm not buying that this work was all done prior to May 5th. When you go to the May 31st picture where it shows nothing was done to that road. That road is not in the same condition that it was on June 2nd. So I'm on previous things. So I'm concerned about that on what's being said there. I'm also looking at the picture where it was actually scraped, and you can see that this is scraped, 21,000 foot or whatever. That doesn't look the same as the previous picture on March 31st. It doesn't have all of this grass area and all of this done. That's been done after that. These are all been removed. This has all been removed here. This has all been scraped down. So as far as what's being said here, I don't see that the grading, I believe grading was done in here. Just from how wide this is here and how that's all has heavy growth on it. On this picture, it's now wider. Testimony be given here is he cut a road in. He didn't say he removed brush on it. And he's an experienced contractor. That's what he does for a living. He said he cut a road in. So that's the testimony that's been given to us here for us to judge on the spot. So that's what I'm looking at right now. Supervisor Mill, yours light is on?
Yeah, just for the record, I have been referring to a cubic yards contract or a calculator here in case anybody wanted to know why I was flashing my phone around. So it came up 150 times 75, even if it's 1 inch deep, is 30, almost 35 cubic yards, just for reference.
Supervisor Oliveira.
Once again, Supervisor Tofinelli, you answered my question. Thank you.
Mr. Chair, may I just comment on one thing you said?
I'll give you 2 minutes.
That's
like
all I
did
need.
Previous, and that's it.
So this road here is not at issue here. What's at issue is the cultivation area. Access to it and from it is not part of it. And this area over here is not part of the cultivation area. It's just not relevant to the inquiry here, which is whether or not this area was the subject of earth moving. And in my last 10 seconds, Mr. Moorer said that there is a measurement rule. It is not. The ordinance simply says earth moving in an area commensurate with the area to be cultivated. It's not a measurement of how much earth, it's a measurement of the square footage. It has to be consistent with the canopy that was applied for, not the amount of earth moved. Thank you.
Board Chair.
Yes.
I just wanted to clarify for this board, there's been a lot of discussion about language of the urgency ordinance, what earth movement is, how to interpret it, things of that nature. And I just want this board I want to reiterate to this board, I know we've had discussions about this in the past in prior appeals, but that ultimately this board interprets the language and the intent of its own ordinance. So what earth movement is, what commensurate with the cultivation area is, that is in this board's discretion as far as how you interpret the language of its own ordinance. And so ultimately this board needs to interpret what the language of the ordinance says and apply it to the facts that are presented to you.
Thank you.
Thank you, Counsel.
Supervisor Oliveira.
Mr. Chair, I do have a question. Mr. Mauer, is there a requirement when you are grading earth moving for the purpose of cultivation of cannabis, is there a requirement for any type of grading permit? And is that based on any standard of the amount of dirt removed?
There are standards that the Public Works Department has for issuance of various grading permits, or I don't have the language right in front of me. Even if you are, I believe it's 50 cubic yards is the threshold for an actual grading permit. But there's a grading letter, I believe it's required for less than that. and the purpose is to ensure there's proper erosion control and things like that, even if you're not moving a lot of dirt itself, that permits are required or authorizations required from the county to do earth movement.
And in this particular circumstance, would that letter, that grading letter, be required for the cultivation of cannabis on this particular plot?
Well, I don't know. It would appear, but again, we're looking at an aerial image. I'm not looking on the ground. I don't know how deep any cuts were for this site. And so it's hard for me to tell whether or not this would cross the threshold for an actual grading permit. That would be something an engineer would have to make a determination on.
And one final note, to your knowledge or to planning department's knowledge, there was no letter such stating in the file, is that correct?
There's nothing like that in the file.
Thank you, Mr. Chair.
Any other board questions? If not, we're going to close the hearing. I'll close the public hearing at this time. And we'll come back for board deliberations or discussions. Supervisor Mills, I see you're about to turn your light on.
I think it's very clear from the photographic evidence that the activity occurred after May 10th. There's nothing here to support that it was happening before, other than just simply vehicles driving in there, turning around, and driving out. Everything else just keeps coming back to this would not have happened had they, and I'm talking about the whole area, including the driveway, would not have happened if they weren't going to grow in that location. So I can't separate the outside perimeter from what happened on the inside of the perimeter simply because it all works together. And that is my greatest concern is how much additional that was done here on top of just the plot plan itself for the grow.
I'll have to agree with you. It all fits together. It all is part of the cultivation site itself. In order to get there, what you needed to do to get there, to access it, to bring in whatever you needed to bring in, to do your grow there. So it all fits in. It all sets up for you to be able to do what you're showing here on the photo for your grow. I'm seeing other things there that actually had to be brought in. So I'll have to agree with Supervisor Mills and that it's all germane, it's all together. Any other comments? All right.
Point of order, please.
Point of order, George, what?
Have any of you supervisors been out on the site?
That's not a point of order.
Yes.
That should have been a comment or a question asked during public comments, George. Thank you. I'm open for a motion at this time.
I would make the motion to uphold the Planning Commission's denial of this application, following the guidelines that were set forth.
I'll go ahead and second, Mr. Chair.
A motion by Supervisor Mills, a second by Supervisor Oliveira. I'll call for a vote. All in favor?
Aye.
Opposed? Passes 4-0. Can you, yes, ask Supervisor Clapp to return, please. All right, Madam Clerk, item number 8.
Item number 8, planning, conduct a hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-832 for Ortal Gabe at a site located at 5340 Hava Road, McCollum Hill, APN number 016-024-057.
All right, we're all in the room, so planning.
All right, once more, this is Miguel. I'm here to present 2016-832, which is an appeal of a Planning Commission's denial of an appeal of the Planning Director's denial of application 2016-832. The reasons.
Miguel, is the
Yes.
applicant present? You are, okay. I just want to make sure before we go through this, you're present.
Yeah, I'm filling in for my colleague, Mr. Molinelli, so I'll handle the presentation on his behalf.
All right.
Thank
And
you.
your name?
Adrian Lambie.
Mr. Lambie.
All right, so this registration was denied for similar reasons as the previous one. Earth moving or grading occurred on the parcel beyond the May 10th, 2016 deadline for the purpose of establishing a cultivation site. The registrant also failed to produce any documentation that or photographic evidence that showed cultivation happening on the parcel prior to May 10th, 2016, or any photographic evidence of earth movement or grading commensurate with the area to be cultivated prior to May 10th, 2016. And lastly, there were some images that were submitted, but the planning department found them to be false and misleading, and that's another reason for denial. Just real quick, the 5-acre parcel is located at 5340 Harbor Road, Moke Hill. This is the plot plan that was submitted with the registration. As you can see, the registrant depicts a 22,000 square foot cultivation area over here. Above it, you can see an access road of sorts. However, aerial imagery from May 31st, 2016 does not show what the plot plan depicts. This is where the cultivation area was depicted in the plot plan. You can see because of the access road that loops around it. And as you can see, there is no cultivation taking place in this area. This is a county aerial imagery from June 3rd, 2016, just a few days later from the previous image. Still no cultivation taking place. However, when we jump to August 20th of 2016, there is a stark difference between June 3rd and August 20th, as in this whole swath of land and vegetation was cleared for the purposes of cultivation. You can see rows of pots of cannabis. The access road got shifted north. These are the photographs that were submitted with the registration. This photo is from July 5th, 2015. However, during the Planning Commission hearing, it was established by the appellant and his counsel that this photo was in fact not accurate, or it didn't belong with the packet. It was an incorrect photograph that one of the appellant's workers took and submitted, but of perhaps an incorrect parcel. So this photo, in reality, holds no relevance. This photo, however, is the photo that the appellant and his counsel indicated to be the photographic evidence of cultivation taking place prior to May 10th of 2016. This photo is dated April 26th, however, there's no year. It's to be assumed that April 26th date was from 2016. Just real quick, as you can see, there's an open field. We have a tractor moving earth. We have a few workers. However, aerial imagery from, actually this aerial imagery is from 2015. Aerial imagery from May 31st, 2016 shows nothing that reflects this photograph right here. Month later, we have no indication that this photo was was in fact taken on that parcel on that date, showing that cultivation activity taking place. As previously stated, activities not occurring on the parcel, activities required to occur prior to May 10th. None of this had happened. This is why the planning department deemed those photographs to be false and misleading.
Sorry for the confusion. This appeal actually was handled by another planner who's no longer working for the county, so Miguel graciously offered to step in and present the item, but I think we can just skip over this slide. So in this case, the appellant is stating that, yes, he admits that the one photo submitted was not accurate, but he did arrive in Calaveras County in 2015, began cultivating, and then in 2016 did some grading, claims it was on the site. Again, we have no evidence of that, but is followed up with a grading permit application, paid the taxes, that was basically the basis of his appeal before the Planning Commission. Some of the information, the one photograph that showed the tractor and the grading, and there was an outhouse in the background. The claim was that spot there was I can't remember if that was the tractor or the outhouse, and that was the area where the grading was occurring in that photograph. If that was the case, it had nothing to do with what ultimately became the cultivation area. And again, we don't see any evidence of any grading having occurred in that area. There was a little white spot there that it's hard to tell what it is, again, based on the quality of that image. But you can clearly see that it's just an open field, natural vegetation on the site. And again, there's nothing really showing on May 31st that the area within the loop of the road, that any cultivation activity had been occurring on this parcel. So I guess, maybe just rather than go through these slides, which we're not that familiar with, I apologize. Our position is that there was, the misleading evidence of the photographs, and, whether, like the last one, whether intended to submit it or not, that was all we had for evidence of prior activity. We have no evidence of the grading activity occurring. By looking at the aerial photos, there's no signs of any kind of grading that had occurred on the site, and that clearly they graded well beyond that after May 10th, as shown in the August photograph from 2016. So those were the reasons for denial, and those reasons for denial were upheld by the Planning Commission for those very reasons. Do you have any questions of us?
Any questions of staff? If not, we'll hear from the appellant.
Good afternoon, supervisors. My name is Adrian Lambie. I'm a colleague of Mr. Molinelli's at Archer Norris. I'm filling in for him with respect to this appeal because an urgent matter prevented him from being here. So, like the planning department, I have done my best to familiarize myself with this matter, but I too did not handle the underlying planning commission appeal, so I apologize in advance for any gaps in my knowledge, but I will do my best. First and foremost, I want to address a matter that was raised by Mr. Molinelli in a letter to this board at the end of last week, which relates to the jurisdictional and decisional basis for this appeal. As set forth in that letter, which I hope you have had an opportunity to review, it is beyond doubt that the urgency ordinance upon which this registration and the ensuing denial are based has expired and is no longer in effect. It expired on its own terms on February 14th. Now, it's obvious this board has passed what is intended to be a successor ordinance to the urgency ordinance. That is in the form of the ban ordinance that was passed on January 10. However, pursuant to Section 25124 of the Government Code and to Section 5 of the ban ordinance itself, that ordinance does not become effective until 30 days after its publication in a newspaper of general circulation in the county. My understanding is that the newspaper for official notices, and I think we touched on this earlier, for the board is the Valley Springs News. The ordinance was not published in the Valley Springs News until February 7, 2018 is my understanding. 30 days from that date of publication is March 9, which would be by the ban ordinance's own terms and the applicable provision of the Government Code when that ordinance becomes effective. We therefore find ourselves in a vacuum wherein Chapter 17.95 of the county code, wherein the ordinance, the urgency ordinance was previously codified, has been rescinded. That is no longer the law of Calaveras County. And the successor ordinance has not yet taken effect. So, as a consequence of that, as Mr. Molinelli set forth in his letter, we would submit that there's no decisional basis for the board to decide this appeal. The code section on which the very denial is based, right, which was 17.95.170, that code section no longer exists, and it hasn't been replaced with anything, which presents an interesting quandary of what to do with administrative hearings that are ongoing during this period. And as submitted in Mr. Molinelli's letter, we think the case of Governing Board versus Mann is germane to this issue. In that case, you had a teacher who was dismissed from his position, coincidentally enough for possession of cannabis. He appealed the school district's decision to dismiss him on that grounds. In court, the trial court found against the teacher and upheld his dismissal. He appealed that decision to the Court of Appeal. During the pendency of his appeal, the statute authorizing his dismissal for possession of marijuana was rescinded, or repealed more accurately by the state legislature. Presented with the question of what to do under those circumstances, the Supreme Court of California said, well, it's simple. We have to rescind this teacher's dismissal because the statute that authorized it in the first place is gone. And the appeal is immediately terminated because there's no basis on which to appeal this decision anymore. Substantially the same thing has occurred here. We have a registration. That registration was denied based on 17.95.170 of the county code. Before that decision can become final, of course, the applicant is entitled to exercise his administrative appeal rights, which is what he has done. During the pendency of that appeal, the statute on which the denial was based has expired. There's no successor statute. There's no language in the urgency ordinance that suggests it's intended to last beyond February 14th. Indeed, that might be unlawful under the state authorizing statute for urgency ordinances. So we would submit that the exact same outcome as occurred in Governing Board versus Mann ought to occur here, which is that the denial must be rescinded. And I anticipate a response from counsel, which is that, okay, but so why are we here at all, right? Aren't the registrations also expired? Aren't they of no moment? And I would point out that under the urgency ordinance's own terms, the registrations issued under that ordinance are intended to survive the expiration of the ordinance. Indeed, they survive for 90 days after a successor ordinance takes effect. But the remaining provisions of the urgency ordinance have no such language suggesting that they ought to be prolonged following expiration of the ordinance. So under that fact set, my office submits that there's no basis for the board to make a substantive determination on this appeal because the statute that would have allowed it to do so is gone and hasn't been replaced. Instead, what ought to happen is the denial ought to be revoked and this appeal process terminated. And at that point, our client will join the remainder of the applicant pool in this county whose registrations will expire as a consequence of the ban ordinance taking effect. So I want to address that issue. I wanted to address that issue first and foremost because I think it is potentially dispositive of this appeal. That being said, I will talk briefly about the merits of the case as an alternative argument, and I don't want that to be construed in any way of a waiver of what I've articulated already. But in the event that the board does feel it has the jurisdiction and sufficient statutory guidance to proceed with the appeal, I would point the board's attention briefly to the declaration which was included in the staff packet wherein Mr. Gabay, my client, explains that the reason he submitted the photo that ultimately was determined not to be of the correct site was because he didn't have any firsthand knowledge to discern that. He was relying on photos provided to him by an employee because he wasn't in the county at the time the photos were taken. There was clearly a mistake or perhaps even a misrepresentation, an intentional misrepresentation of that employee to Mr. Gabay. In any event, he inadvertently submitted 2 photos, one of which was of the incorrect site, and one of which he maintains was of the correct site. And I think we've heard from the department their hypothesis that that second photo, which shows the outhouse and the tractor doing some grading. Oh, yep, right there. So we talked about the hypothesis that it's in the northerly, that was actually taken in the northerly part of the parcel where we do see some clearing and a potential cultivation site from 2015. I think the department finds that unconvincing, but we have Mr. Gabay's declaration to the contrary. So what in effect happened is there was a cultivation site that was too close to the property boundary. In the northerly part of the parcel, it would have been well within the 75-foot setback. So to Mr. Gabay's understanding of the ordinance, he was entitled to what's been termed a proportional adjustment to relocate the site out of the 75-foot setback zone to a more appropriate area in the interior of the parcel. It's not disputed that the correct protocol for that relocation was not followed. That was based on ignorance by Mr. Gabay, not based on any intent to flaunt the ordinance. And I believe he has expressed regret and contrition for that decision at prior hearings, but nonetheless, it was made in good faith and in error. So I would just submit that to the extent the board reaches the merits, it should consider that this was not, as may have been suggested by the department, an entirely new cultivation on this parcel. There was existing cultivation, it was just in a different place, and it was relocated by Mr. Gabay, believing in good faith that he had the right to do so, not realizing that there were additional submittals required to the planning department to do that. So with that, I thank you for your time, and I'd be happy to answer any questions.
Any questions from the board? No? Yep.
Just so I'm crystal clear. So Mr. Gabay is claiming that we could go, there's other photos, but he was growing on this in 2015 prior to the fire. That's where this picture was, I'm assuming that's obviously prior to the fire. And with the setbacks and our new rule, he then subsequently moved his grow to a different site on a different plot.
That's accurate with the exception that I don't think it was Mr. Gabay who was doing the cultivation. There was cultivation on the site in 2015, and so he arrived on the scene after that fact. But other than that, I believe that's correct.
Council, or Peter, does that matter in an application? I haven't faced this one before.
No, it doesn't matter who was doing the cultivation, whether or not there was actual cultivation going on the property prior to May 10th, 2016. And then number of other requirements as far as ownership or lease agreement with the property owner.
So are we disputing whether they were growing in 2015?
That's correct. The issue here is whether they actually were cultivating on the site prior to May 10th.
The only evidence that we have that they were is this photo, which is declared not correct, correct?
That's correct.
Not this photo. This photo is the one that's declared not correct, 2015 one. This is the photo that's
Can you
declared.
take me back to the post-fire aerials? Yeah, that one. And they're saying that, look at this. These are great. They're saying that this is where they're growing before the fire?
I believe so, yes.
And then after the fire, this was the second grow was,
Yeah. Oh, sorry about that. Yeah.
so this was a prior to the fire grow, this is post-fire grow down here, correct?
I believe that's correct,
That's
Supervisor.
what we're talking about. I don't suppose we've gotten any aerial images of 2015.
July 27th, 2015.
All right, so this is the same spot, right?
Correct.
Where they said they're growing in 2015.
Correct.
So it would be in the ground or on the pots by then. Counselor, is there any debate about this photo?
No, I don't think that shows any plants. I think that's beyond dispute. It does show a cleared area up there, but I agree. It appears clear that there were no plants there when that photo was taken.
Thank you.
Yep.
Any other questions? No? Supervisor Oliveira.
Mr. Chair, I'd like to hear from council on the first issue discussed by council.
We're getting to that.
Okay?
Any other questions? No? Council?
Mr. Lambie brought up the Mann case, and I think that there are a lot of distinctions between the Mann case and what we are facing right now. Under the Mann case, it was very clear that the law that was in question was repealed by the legislature with the intent of actually reducing the restrictions that were in place. In this situation, we have something very starkly different in that the board didn't remove the urgency ordinance with new legislation to reduce restrictions, but rather to adopt more restrictive requirements on all of these applicants. And although there is a time period in which the urgency ordinance terminated on its own term and the implementation or the effective date of the new ban, it does not mean that the county is without or is lacking any type of statutory authority at all. And I think that is a major distinction, because although the ban ordinance has not become effective, the county does have an undisputed permissive zoning code. And under that, it does prohibit all land uses not listed as permitted in any zone, and cannabis is not listed as permitted in any zone within the county. So although there isn't an express ordinance for this time period of approximately 2-3 weeks, there isn't a lack of statutory authority that the county cannot rely on in this interim period. So I think there are certain distinctions between the Mann case and what we're facing today.
Mr. Chair, if I could add to that as well, Mr. Lambie indicated he believed that there's no express language in the urgency ordinance that would carry on those restrictions past the expiration date. But there is. There is the 90-day period in which cultivators can continue to comply in compliance with the provisions of the ordinance. So we are still operating under those provisions. So anyone that was cultivating either through an approved issued cultivation registration or an application pending status where we haven't quite completed the review process, still must comply with the provisions of the urgency ordinance for a period of 90 days. So I would agree with Megan that there are distinctions. I think this is a very clear distinction here where we have language in the urgency ordinance that carries on those criteria from the urgency ordinance for anyone wishing to continue to cultivate after its expiration has to comply with those provisions. So this is not in compliance with those provisions, and so there's no reason to just simply grant the appeal or claim that it's no longer necessary. In order for anyone to continue to cultivate under the provisions of the urgency ordinance, they have to be in compliance with those provisions.
And Chair, I would also just also indicate that appeals are necessary. I mean, it's the administrative process, and so appeals are a method that all registrants have to go through to exhaust their administrative remedies. So to say that the appeal is no longer necessary, that would in essence be saying that there is no longer an administrative process in which they can avail themselves. And so certainly all applicants who are denied, that were denied while the urgency ordinance was in place, has the duty to exhaust their administrative remedies before this board, before they can pursue any other challenges.
Thank you. Any other board questions?
Now, Mr. Chair, Mr. Mauer, are we still processing applications?
Yes, we are.
Okay. And do we have an idea of how many more we have to process?
I think we're in the range of about 150.
Okay. Thank you, sir. Thank you, Chair.
And you'll have a chance for rebuttal in just a minute. We got to open it up to public for public comments. Any public comments on this issue? No? Okay, seeing none. You're up for rebuttal.
Time flies. A few points in response to what was said by Ms. Stedfeld and Mr. Mauer. Firstly, with respect to the concept of permissive zoning providing the statutory authority for the board to decide this case in the gap period between the expiration of the urgency ordinance and the effectiveness of the ban. Whether or not a permissive zoning code provides that authority, and for instance, whether or not cannabis cultivation is properly classified as an agricultural use, which is allowed in certain zones, those are all points of debate. And if the board wishes to rely on the permissive zoning code to rule on an appeal under the urgency ordinance, firstly, I would ask that that be expressly stated in the board's findings, because if that's going to be the decisional basis of the board, we need to know that. Secondly, I would object to that approach. I think that while certainly there's room for disagreement as to the meaning of the permissive zoning code in the absence of cannabis legislation, I don't think there's any procedural device out there that would allow that decisional basis to be shoehorned in to an appeal that was initiated under section chapter 17.95 as it previously existed. I think those are, while a valid issue, no doubt, it is a separate issue. And I don't think that it provides the board with a basis for going forward today. And that segues into what I was going to say in response to Mr. Mauer. I understand that there is a requirement that cultivation, to the extent it occurs during the 90-day ramp down period at the end of the ordinance, comply with the county's rules. But the point that I'm making is that the statute that provides the decisional basis for this board to make its appellate decisions, right? 17.95.170, which specifies the grounds for revocation and termination of a license. It's undisputable that that statute is no longer on the books. There is the idea that that statute or that code section is somehow implicitly extended by the urgency ordinance, I think A, is not, doesn't have a basis in the text of the ordinance, and B, might well violate the limitations on urgency ordinances. It seems counterintuitive to say, well, this ordinance is going to expire on February 14th because indeed it cannot run longer, which is what the board determined a year ago, and then continue to apply the very provisions of that ordinance beyond February 14th. That would seem to countervene the whole concept of the expiration, the forced expiration of an urgency ordinance. So the fundamental problem that I'm laying before the board is there was a statute that used to tell the board how to determine these appeals, right? Here are the grounds for denial. Were these grounds met in this particular case? That statute no longer exists. There is no measuring stick by which the board can decide this appeal. And if the measuring stick is to be permissive zoning, again, I reiterate my request that that be made express in the board's decision. Thank you.
Board Chair, I would just like to comment on that.
Yes.
And I don't believe that it's permissive zoning that would be the basis for which they would be denying. It's allowing for the interpretation of the urgency ordinance, which is the basis for denial. So when I referred to permissive zoning, I'm referring to the distinction between the Mann case and what we're dealing with today. And that the county does have what could be perceived as a permanent ordinance on the books that has historically been there undisturbed for quite some time. And so for purposes of the appeal, the board has the duty to assist appellants in exhausting their administrative remedies to hear the appeals and to rule on the appeals so that they can go through that process. So for purposes of this appeal, it's applying the rules that were on the books when the application was accepted, when the application was denied, and the basis for that denial. And then certainly you're applying the rules of the urgency ordinance, and then you are also, in essence, assisting the applicant to exhaust their administrative remedies to pursue other avenues that they see fit, but certainly the appeal process is something that is necessary.
If I might be permitted, just one brief response.
I'll give you 2 minutes.
Thank you. With respect to the Mann case, which we've talked about a lot, I think it goes to the crux of what Ms. Stedfeld suggested. She indicated that because, or at least in partly because there's an administrative exhaustion requirement, that the board ought to decide this appeal based on the standards that were in effect at the time the appeal was initiated. However, the Mann case stands for exactly the opposite proposition. And I'd like to read a quote. The reviewing court must dispose of the case under the law in force when its decision is rendered. So in other words, it's not the case that you look at what was the state of the law when an appeal was initiated, and then you ultimately decide the appeal under the state of the law as it then existed. You must decide the appeal under the law as it exists at the time of decision. So I think the idea that you can give post-mortem effect to these provisions of the urgency ordinance doesn't stand up to scrutiny. Thank you.
Thank you. Staff, you have any summation or rebuttal before we discuss this at the board level?
I would ask that the board proceed with the appeal under the old rules and not make any findings about permissive zoning, authorizing them to do so, authorizing you to do so. I think permissive zoning, as Ms. Stedfeld indicated, is really just to point out that there is no gap, that law of the land exists at all times. And to say that there is a privilege that hangs in the balance here, and that's the privilege of Mr. Gabay to continue to cultivate during the termination period of 90 days. And that privilege was revoked by the planning director, and on the basis that were set forth in the staff report. Though that basis was upheld by the planning commission, and all we have to do here today is determine whether or not those decisions were correct.
So I will, well, first off, is there any questions by the board members so far? I will poll the board on whether they want to continue with this applicant process, the appealant process, and go forward. Supervisor Mills?
I would not want to include permissive zoning in this decision.
Supervisor Glatt?
Say.
Supervisor Oliveira?
I would agree with Supervisor Mills. I would consider the actual original basis for the appeal, though.
Okay. Supervisor Garvin?
I concur.
So do I. So we'll go forward. At this time, is there any other board questions on this item for staff? Supervisor Mills.
I want to go back to the grading of an entirely new area. Very different from the original area that is being discussed, possibly discussed. Did we engage Public Works in this one?
I'm not sure what you mean by engage.
Did they get a permit? Did they go through any kind of process?
I believe that after the fact, they applied for a permit with Public Works for the grading that's depicted in the late 2016 aerial image. Is that correct in reality?
I believe so. I don't think it's been finalized or any of that.
So there's no permitted grading.
There was no permit
the-
issued prior to the grading having been done. A permit was applied for after the fact. I believe it's still probably waiting for additional information or hung up in Public Works for one reason or another.
As far as you know, they have not been issued a
They
permit.
had not been issued a permit.
Miguel, can you go back to the 2016? That's on.
This one?
Do we know if they actually graded?
Whoa.
Kind of looks like it.
That's August there. You have one from July 2015, July 27, 2015.
Is that 22,000 square feet? Pretty big.
Yeah, it's bigger than,
It's a little bigger than 22.
What's the one below it?
right there. My issue with this particular photograph is the amount of land that has been converted from timber to bare ground. And I think the other agency that would have or take extreme exception of this, but we'd have to talk to them, or they would, is CAL FIRE. Because this is land conversion of its worst kind.
We did receive a number of letters from CAL FIRE about illegal conversion. This was not an issue with this one. We did not receive notification that illegal conversion had occurred. It could be that they just didn't get to it. So much other conversion was occurring throughout the county. Not a basis of the denial, but it certainly appears that that happened.
I just only bring it up as a point of how much land was converted over to just something that was bare. And with grading, of course, the concern is, are we containing the soils? Are we compacting the soils? Are we protecting the watershed? And I'm not certain that all happened here with the subsequent photographs. So if you flip forward into the May 31st, that one, back, right there. This is just how much grading occurred there, and of what part of the watershed was impacted by all of it, including what's on the other side of the road, not just what's within that boundary, but outside of the boundary on the other side of the road. It's substantial.
Could you go back to the May 2016? There you go. That's post-fire, and I'm not going to debate the grading or where it was moved, but I think we ought to be very careful about talking about conversion of forest land. That is burnt to a crisp. Fire went right through there. Most of those trees, with the exception of the little ribbons in there, are going to be dead. And so whether they're growing cannabis or not, those people were clearing dead wood off that property. And that's a good thing for our county because it reduces future risks. So let's be careful about, in the burn zone, talking about cutting down trees for conversion because those trees are dead.
Under CAL FIRE rules, even the harvesting of dead timber still requires various permits from the state.
Well, I think we have to apply a little bit of common sense in this county once in a while.
Well,
And that would just be absurd.
I'm just stating what the facts are.
Any other questions? Comments? Is there any public comments? Seeing none, we'll bring it back to the board. We'll close the the hearing for board discussion and deliberations. Any deliberations, any questions, any discussions? Seeing none, I'm open for a motion on this item.
Mr. Chair, based on the information provided by council and the indication of the incorrect photograph being supplied with the application, I would move to uphold the decision of the Planning Commission regarding this appeal.
I have a second.
I'd second that.
I have a motion by Supervisor Olivera, a second by Supervisor Clapp. Call for a vote. All in favor?
Aye.
Opposed? Passes 5-0.
Thank you.
Madam Clerk, item number 9.
Item number 9 is planning, conduct a public hearing and adopt a resolution denying the appeal filed by Adrian Lambie on behalf of Rafael Calderon on the denial by the Planning Commission for reconsideration of the denial of the appeal of the denial by the Planning Director of Commercial Cannabis Cultivation Registration 2016-106, 2016-1123 appeal.
Mr. Bauer.
Good afternoon, Peter Maurer. This is an appeal of the Planning Commission's decision to not reconsider the appeal of the cannabis denial. So, step back a little bit. This was a denial based on, in October of 2016, at the old airport. There was concern about activity going on there, number of sheriff's deputies and
Board
fire
Chair.
personnel.
Yes.
Sorry for the interruption, but I believe that Supervisor Clapp has something he would like to say.
I'll be recusing myself from this. I recused it on the last hearings and stuff on it. Thank you.
Chair, before we go forward, could I take a moment with council outside?
Sure you can. Let's take a 5-minute break.
Okay. Based on the fact that I had recused myself from this particular matter previously, I will recuse myself again because of my knowledge of the case.
Okay.
Okay, appreciate it.
Mr. Chair,
Supervisor Garamendi.
I have some outside knowledge of this case insofar as when this was going on, the bright lights flashing made me pull over, and I said hello. I was there very briefly and then quickly departed. So I do not think that prejudiced me in any way regarding this case or any of the hearings,
I
but
think you brought that
all
up.
disclosure.
Yes.
Done again.
All right, so there's 3 left. Mr. Maurer.
Well, to sort of expedite the process here, after a series of appeals, denial by the Planning Commission and appeal of that decision to the Board of Supervisors, the appellant requested that it be, that the matter be reconsidered by the Planning Commission prior to the board's action. However, the board declined to remand it back to the Planning Commission and took action to deny the appeal. Subsequently, we took the request for reconsideration back to the Planning Commission. The Planning Commission found that for 2 reasons not to grant reconsideration. One was they did not believe that the language of the ordinance actually allowed for reconsideration of an appeal, but rather it was meant for reconsideration of an entire project, in that the project itself would have to be reapplied to the Planning Department for full review and then a hearing before the Planning Commission. The second reason why that they denied it was, well, actually it was the primary reason, was they could not reverse a decision that had already been made. In this case, the board had already denied the appeal. That action was final, and the course of action from there would be to appeal the matter to the courts. And so the Planning Commission looked at that and said, we have no authority to override a decision made by the board already. They are a higher authority, and so they refused to reconsider the matter based on that. The appellant subsequently appealed that decision, and it's now before you. In the meantime, the ordinance that looked at the reconsideration process has been revised. Previously, the portion of the ordinance that they're basing the request for reconsideration on reads, "No reconsideration of any portion of a project may be appealed after the appeal period has expired. A project reconsideration filed after the appeal period has expired shall be processed by the Planning Department, and a public hearing shall be conducted by the Planning Commission. The request shall be filed with the Planning Department and shall include appropriate fees, maps, and justification for the reconsideration." So we have interpreted this, again, to mean that the entirety of the project, not just the last decision on the appeal, but the whole project. This would be intended for, say, a subdivision map or a conditional use permit or something along those lines, where it was denied, perhaps denied without prejudice. They could resubmit, and we could reconsider that same project. In this case, we're looking at the narrow aspect of the overall project being just the appeal. That section of the code has since been rescinded, and there's been some revisions to the remainder of the Chapter 1795, the appeal process, and the procedures under 1798-070 that clarifies the process that we are now under. However, in light of our previous discussion on the Mann decision, we believe that they are allowed to operate under the terms of the ordinance that existed at the time that they applied, as well as the time that this appeal was filed. And so we believe that subsection B, 070B, applies in this case, but it doesn't allow for just an endless loop of reconsideration every time you don't like the decision the Planning Commission made. If you want to have reconsideration, you resubmit your whole project, and we'll start over again. In this case, they cannot resubmit the whole project because our ability to accept an application ended on June 30th, 2016. So the Planning Commission's recommendation, or the Planning Commission's action, was to deny the request for reconsideration based on the two provisions that I outlined, and staff recommends that you uphold that determination.
Okay. Question? Appellant.
Good afternoon, Supervisors. Adrian Lambie, once again, this time on behalf of Mr. Calderon and Mountain Farms, Inc., the appellants in this matter. Just as before my last presentation, I would like to raise the issue of the expiration of the urgency ordinance, including the code sections which would allow the board to decide the merits of an application denial. That code section no longer exists, and a successor statute has not yet taken effect. So on the strength of that, we would request that the denial be reversed and that this appeal process be terminated. I won't go back into great detail about the underpinnings for that decision, if it's all right with the board for me to just incorporate that prior statement by reference.
Sure.
Okay.
County Council?
And sorry, for purposes of this appeal, this is one difference between this appeal and the last one. I would like to note an objection in the record as to the dual roles of County Council advising the board and representing the Planning Department, which functions as the prosecuting authority with respect to this appeal. So I would note that objection.
Couple of things. One, as to the nightlife reference that Mr. Lambie just made reference to, and that is the dual relationship or dual counsel position as it relates to the County Council's office. There are multiple cases on point that are clear that for agency representation, we have the ability to both have a prosecutorial arm and an advisory arm. It is very clear, and we've made it a point within my office that I here am representing the board in an advisory capacity. Mr. Turner has been assisting planning through the processing of applications, and to the extent that his assistance with planning could be construed as prosecutorial, there has been a division within our office for the prosecutorial portions of his function and the advisory function that I am here for this board. As far as the Mann case and the comments that were previously made in the prior agenda item, I would just ask that all of the comments made by Mr. Lambie and all of the comments made by myself were also included in the record. But I would want to remind the board that this appeal is not about the urgency ordinance and whether the urgency ordinance is in effect or not. This appeal has to do with reconsideration, because the application and the appeal on its merits have already come to this board. So the question before this board is whether the Planning Commission had the jurisdiction to hear a motion for reconsideration after the board had already taken action on the merits of the case. And so that is really the premise of this appeal, is whether the Planning Commission could hear that motion for reconsideration and go back to the merits of that original denial after the board had taken action or not. And if this board were to rule that yes, they did have jurisdiction, the actual merits of the original denial would have to be remanded back to the Planning Commission to have a reconsideration hearing on that. So this is really about motion for reconsideration. It's not about the urgency ordinance or about the registration or about the facts that are relevant to that case, or to that denial, I should say.
May I proceed with my presentation?
Yes, you can.
Thank you. With all due respect to County Council, yes, it is true. The reason that we got to this point procedurally is the reconsideration issue. However, the reason why all of this matters, right? The reconsideration that was being sought from the get-go was the ability of my clients to introduce evidence of differential treatment of other applicants with respect to the appeals process. As the board may recall, during the prior appellate phase, we attempted to introduce evidence to the board that was obtained after the Planning Commission hearing regarding the treatment of other applicants as compared to the treatment of my clients. That evidence was not accepted by the board because it was new, and a request for remand to the Planning Commission to present that evidence was denied. By the time the Planning Commission subsequently got around, after an apparent change of heart on that front, got around to hearing it, the board had already rendered a decision in its appeal, and as Mr. Maurer explained, the Planning Commission, on the strength of that, declined to hear the request for reconsideration, determining that they lacked jurisdiction to do so. So that's how we got to this point, and ultimately the reason why we got to this point was an effort to introduce merits-based evidence related to the underlying denial. Again, the statute that authorized the underlying denial is no longer on the books, so we've noted our objection on that grounds. Now, turning to the issue of reconsideration, I won't belabor the record because I've appended a lengthy slide presentation to the materials that the board has already. But the short version is this. From our perspective, requests for reconsideration are a good thing from a public policy standpoint and are required under the county code. And the reason why they're a good thing from a public policy standpoint is they allow the introduction of potentially game-changing new evidence, as my client sought to do in this case, without the administrative red tape and the personal expense of starting the entire process over again, or of continuing to pursue appellate remedies into the judicial system, which indeed my client has had to do. If only this evidence could have been timely considered by the Planning Commission, it would have promoted more effective disposition. Maybe the Planning Commission ultimately is unswayed, but it would have promoted a more effective resolution of the case to be able to introduce the pertinent evidence that was obtained after the original hearing, before the train proceeds down the tracks on the way to a judicial appeal. There's a procedure very similar to this in the court system called CCP 1008, which allows someone, a litigant, to move for reconsideration based on a change in law or new facts. And just because that motion is made, the body, the court that's hearing the motion, isn't required to grant it, isn't required to consider it, right? They have the opportunity to decide, okay, is there indeed a change in circumstances such that we ought to reopen this issue? So it's not an endless loop, as has been suggested by staff. It is a process by which new materials can be brought to the attention of the people who ought to be seeing that material, because it could affect the decision they've made in the matter. So far from creating an endless bureaucracy, it actually promotes a more efficient handling of appeals. And I think we see that in the courts, where these CCP 1008 motions are not being widely abused and are not tying up appeals and trial court proceedings indefinitely by any means. So there's a sound policy reason to interpret the county code to allow those procedures. And indeed, at the time prior to the revision that Mr. Maurer has alluded to, that appeared to be the intent of the plain language of the code. There's been a suggestion by Mr. Maurer that cannabis cultivation registrations ought not to be treated as projects for purposes of reconsideration, that they're somehow distinct or distinguishable from an application to, for example, do a subdivision or have a lot line adjustment or build some type of structure on the property, and that therefore they ought not to have been treated in the same way that other projects were. And as we pointed out in the Planning Commission phase of this appeal, a cannabis registration application bears all the hallmarks of a conventional development project. It just happens to have to do with cannabis. You have to pay fees, you have to submit plans, you have to comply with various state agency requirements, the Water Board, CAL FIRE, et cetera. There's a review process. There's the issuance of a document. Yes, it's called a registration, not a permit, but what does the registration do? It basically allows you to do an activity on your land that you couldn't do if you didn't have it. That is the functional equivalent of a use permit. And so the idea that because these registrations involve cannabis, they ought to be carved out and treated differently, we reject. And to further support that position, we've looked through the code at what other types of decisions are appealable through request for reconsideration. And there's a litany of them throughout the code. Mineral extraction decisions, fire and life safety regulations, requests for zoning changes, special event permits, whether or not short-term vacation rentals will be allowed in the Lake Tulloch area. So we see a bunch of use issues in the code that are appealable through this request for reconsideration, or are subject to request for reconsideration. And we would submit that there's no reason why cannabis applications ought to be carved out of that. If there's a sound policy basis for allowing requests for reconsideration in other contexts, why not here? And lastly, with respect to Mr. Maurer's point, which was espoused by the Planning Commission in their ruling, that the impossibility of resubmitting a cannabis application is a distinguishing factor here, right? That because there was a cutoff in June of 2016 to submit those applications and they can't be resubmitted, that maybe that's why cannabis registration should be treated differently. Well, again, as was noted at the start of my presentation, that statute's no longer on the books. The statute that would have, that contained that very deadline is now expired. So with that, I'll close my presentation and take any questions the board may have.
Question? No? Thank you. Council, you have a statement?
Yes, I just wanted to remind the board about the procedures that are in the code as it relates to hearing new information. And as this board is aware, all information needs to be presented to the planning department and to the planning commission. And it needs to be any information needs to be presented during those appeal hearings. If there is any relevant new set of facts or information that is presented to this body during its appeal, the board has the discretion to remand the project back to the planning commission. So that's to consider that new information. So that's a separate area of our code than the motion for reconsideration that has been brought forward. So I just wanted this board to be aware that there's already something that this board considered the last time this appeal came to this board for consideration on the merits, and this board did not remand it back to the planning commission pursuant to the procedures that are in this section. So I just wanted to remind this board that there is a process for essentially kicking back an appeal if there is new evidence that you feel would potentially sway or be compelling to the planning commission to consider before rendering your own decision on the set of facts.
Thank you. At this time, you have questions, Supervisor Hall?
I do, Mr. Chair. To the board's knowledge or staff's knowledge, is there any new pertinent information regarding this situation that we haven't already heard through the appeal process?
Not that I'm aware of. And I would reiterate also that this appeal is not as to the merits of the denial. It really has to do with the interpretation of the former 17.98, I believe it was 060B, and doesn't have any information relevant to the denial should have been considered at the appeal on the merits.
Thank you, Counsel. Thank you, Mr. Chair.
I'll open it up for public comment at this time.
This may be when I get my question answered. What is the difference between the first two agenda items and the second two, where one says commercial medical cannabis cultivation and just commercial cannabis cultivation?
There is none.
There is none.
Yeah. It was just a choice of words used by the individual preparing the agenda item.
Thank you.
Okay. Any other public comments? Not, we'll bring it back. It's up to you for your rebuttal.
Certainly. I want to touch briefly on an issue with respect to the Planning Commission's interpretation of how this process ought to work, right? The Planning Commission looked at this and said, well, we can't consider the merits of your request for reconsideration because the Board of Supervisors has already acted on this appeal, and therefore we have lost jurisdiction, right? That was one of the foundations of the Planning Commission's ruling. That presents an interesting predicament for appellants because, as Ms. Stedfeld mentioned, I believe, in respect to the previous appeal, there's a requirement that appellants exhaust their administrative remedies prior to seeking relief in court. So if an appellant feels aggrieved by something the Planning Commission has done, and they would like to potentially have a court review it, they're required by law to pursue their appeal before the Board of Supervisors. Were they not to do that, they would be foreclosed from judicial appeal. So they have to go before the board. But if the Planning Commission's interpretation of the reconsideration process is correct, right? If that act of going before the board deprives the commission of the ability to hear requests for reconsideration based on new evidence, the appellant is faced with a little bit of dilemma, right? They either have to proceed before the Board of Supervisors if they want to exhaust their administrative remedies, but in doing so, they lose their ability to seek any reconsideration based on new information, or not appeal to the board, and thereby preserve their ability to seek reconsideration in the future should new facts or evidence or law come to light that would support a reconsideration. That creates a little bit of a Sophie's choice for the applicants, and I think that the statutory scheme ought not to be interpreted that way since it doesn't have to be, right? Instead, the interpretation that my clients suggest is if there is genuinely new factual evidence or new legal circumstances that warrant reconsideration, and the Planning Commission has already the Board of Supervisors has already acted on an appeal, that the motion ought to be allowable back to the Planning Commission, and if indeed new law or facts have been cited, the Planning Commission ought to consider that as a new submittal.
That it?
That's it. Thank you.
Thank you. All right. Staff. Summation and rebuttal.
There's a couple points that Mr. Lambie brought up that I need to point out are not quite accurate. One is he alleged that I have said that a cannabis project is not like other projects, and that's not what I said. I said an appeal is not a project. An appeal is a part of the overall project processing of a cannabis application. In fact, I agree with Mr. Lambie that a cannabis registration application is a project, and we've determined that it's a ministerial project under CEQA, and it follows more or less the same rules of other projects. And so in this case, Chapter 1798 applies to his project, the cannabis registration, but not the appeal itself as a separate project. And that's the difference that I had made, and I had stated previously both at the board hearing and at the previous Planning Commission hearing. Just to clarify the record, the information, the new information that was alleged to make a difference in this appeal was presented to the Board of Supervisors at its hearing. I believe it was December or January, or December of 2 years ago or January of last year. And the board considered it and found it was relevant to the appeal and found it was not necessary to refer it back to the Planning Commission. And he made that decision after seeing that new information. So there is no new information subsequent to the denial by the Board of Supervisors. So he had an opportunity to present it. The board heard it and said, this doesn't change our decision. It doesn't change. We don't believe it's necessary to go back to the Planning Commission on that. And you chose not to refer it back to the commission, and you chose to take final action. Finally, on the point that the ordinance has expired and therefore there's the date for submittal no longer exists, well, the ability to accept an application no longer exists as well with the expiration of the urgency ordinance. So I think that argument is somewhat moot. So again, the Planning Commission's decision was that you had already decided on this. They no longer had jurisdiction, and even if they did, that the provisions of 1798-060B did not provide for just the appeal to come back, but it was a resubmittal of the entire application.
2 minutes of response, Mr. Chair.
Hold on a second. Any board questions?
I have a quick comment too, if you don't mind, Chair.
Okay.
I just wanted to address the analogy between CCP 1008 and this process for reconsideration that's in the former code. The only thing that is similar between those two statutes is the word reconsideration. A motion for reconsideration under 1008 must be filed with the court, within 10 days after the court has issued a ruling, and certainly can't be filed after an appellate body has made a decision. They're not analogous, and the reason that the 1008 doesn't clog up the courts, as Mr. Lambie's interpretation of this ordinance would, is because they're heard very quickly on the law and motion calendar following the issuance of a final judgment, and they can, as I said, only be requested 10 days after a hearing, or 10 days after a judgment has been issued. I think Peter covered about everything else, so that's all I got.
Okay. All right, I'll give you 2 minutes.
Thank you. Quick response to what Mr. Maurer said with respect to the definition of a project. I apologize if I mischaracterized what you were saying, Peter. But I guess that interpretation begs another question then, which is that if any project, be it a cannabis registration or a request to rent out your property in Lake Toluc, is on appeal, it would seem that the interpretation suggested by Mr. Maurer would then preclude use of the reconsideration project. If you happen to discover, or process, if you happen to discover whatever information is germane that you want to present on reconsideration, if you happen to discover that information during an appeal, then all of a sudden you can't avail yourself of that process. I think that would defeat the purpose, the intent of the statute. And just by way of correcting the record too, the idea that the evidence that is sought to be introduced by my clients was presented in full to the board and the board decided not to remand, that's incorrect. What happened is, out of respect for the board's clear rule that new evidence is not to be presented for the first time on appeal, we did not present the evidence. We made a very brief proffer of the general character of the evidence. We said, okay, here is largely the type of evidence that we seek to introduce in the context of asking the board to remand this matter to the Planning Commission. So it's not the case that the board saw all the evidence, said this doesn't change anything, you don't get to go back to the Planning Commission, because indeed we couldn't do that due to the restriction on new evidence. Instead, we said, here's the general nature of what we seek to introduce, and the request for remand was denied at that time, not after having seen the full presentation.
Thank you. All right. You have a rebuttal to that?
I don't dispute that fact. I'd point out quickly that, if you don't mind, that the analogy that Mr. Lambie just gave, that it would follow that one would lose their right to a reconsideration if new information was discovered upon appeal, would not follow from Mr. Maurer's interpretation of the ordinance, because following your appeals with any other type of project, where there isn't a June 30th deadline in 2016, you could resubmit it. The purpose of a reconsideration is to submit the entire project with the application and the application fee, and you can do that once you've gone through all of your administrative remedies, or even through some of them. I mean, that was the purpose of it. It was just to submit the project, like say you had a subdivision map and there was material defects to it, you went through the appeal process and lost. 2 years later, you could submit the same project, and you'd be allowed to have it reconsidered, even though it's the same project, because there had been substantial changes in fact, presumably to cure the defects that were identified by the planning department or the planning commission at appeal.
All right. Is there any, bring it back to the public, is there any, before I close this, any public comments? If not, okay, I'll bring it back. Any board questions? If not, I'll close the hearing, and we'll bring it to the board for our discussion and deliberation. Supervisor Oliveira?
Thank you, Mr. Chair. Very compelling arguments on both sides of this issue. Although, I think we're talking about a procedure here. And I believe there is one more step to the appeal process that was mentioned, and that was in our litigation. I see the significance of the Planning Commission stating how are we going to reconsider a decision made by the Board of Supervisors when they don't have that authority. I personally would recommend that we give the opportunity to the appellate to seek litigation for an answer on this issue.
You have nothing to add? Okay. I'm going to feel that, I feel that we need to deny this appeal and uphold the planning commission direction. We've already gone through this. We've already denied it one time. It's trying an end around, in my opinion, an end around to try and get back in and have us rehear evidence or send it back to the planning commission to rehear evidence. And I'm just totally in disagreement with that. I think we've already heard it. We've made our decision. I think the planning commission was correct in their assumption that they can't overturn anything the board has done. So that's where I'm at this point in this appeal, or whatever you want to call it. So that being said, do I have a motion of any type to uphold the planning commission?
So moved, Mr. Chair.
Second?
I'll second.
I have a motion and a second. Call for a vote. All in favor?
Aye.
Aye. Opposed? Passes 3-0.
Thank you, Supervisors.
We'll take a 5-minute break for planning to clear out over there. And we are back. Madam Clerk.
Supervisor announcements. In compliance with AB 1234, Chapters Government Code Section 53232.3D, board members shall provide brief reports on meetings they attended at the expense of the local agency at the next regular meeting of the legislative body. This report is required to include meetings attended for which there has been expense reimbursement for mileage, meals, lodging, etc., but may also, at the board member's discretion, include any other meeting attended by the supervisor on behalf of the county.
All right. We'll start with Supervisor Clapp.
Well, I have nothing to report out. You guys got a bargain this last week. I mean, I didn't cost you a dime, so that was a good deal.
Okay. Supervisor Mills, did you cost us a dime?
We cost you a dime because I had to go to Stockton. The Eastern San Joaquin GSA is on track. We have a timeline now established so we can complete the GSP, that's the Groundwater Sustainability Plan, by January of 2020, and that the county share will not change. It's still at the $39,750 roughly for the 4 within the eastern portion of the GSA. Secondly, I went to the Foothill Fire Safe Council, and for anybody that's interested in the mapping, both the U.S. Forest Service and CAL FIRE have got some great maps that they're putting together for like Forest Meadows and Burpees and Arnold, et cetera, as to some of the fuel break projects that they're working on. And they're starting to coordinate because there's a few places where they bump up with private property and they want to be sure that they get that line drawn through in a certain area kind of thing. So if you're at all interested in what they're doing, these maps are available. And I just look at them as some great cooperation between the two agencies. So there's also a grant coming up. You don't know about that yet. Okay. I'll get the details on that and report it in the next meeting.
Grant on
Trees.
fire safe?
Yeah, remember the 10 million?
Oh, yeah.
I'll let you explain that. Okay, I'll shut up and let you explain it.
Okay, Supervisor Oliveira.
Thank you. I'd like to report out on the Governor's Task Force meeting on tree mortality. We did have our monthly meeting last Monday in Sacramento, and information was provided that there are some grants coming. Specifically, there's a $10 million grant for the high-risk counties, which are 14 now. But more importantly was the announcement of the results of the Little Hoover Institute recommendations. And that recommendation may change the picture of tree mortality here in the very near future. There's a movement statewide to form a larger agency called Forest Management Health, and to fold in tree mortality, CAL FIRE, and other federal and state agencies. That would actually redistribute the responsibilities and bring in more folks to join that activity on a bigger scale, addressing the bigger problem. It would not just be fire suppression. It would not just be tree mortality. It would be actual forest health with those activities, cleaning up our forests, providing a healthy situation to prevent fire, prevent tree mortality. So that was very important. We'll have more information on that when we go back and talk with those folks next month. I attended several social events, and I'm tired of crab feeds, but I've got one more to go to. So that's all I have.
He did
Mr.
say
Chair.
crab feeds.
Right.
Thank you, Supervisor Olivera. Supervisor Garamendi.
Yeah, I'm about at the end of my crab feed rope as well. I love them, they're fun, but that's a lot of crab in a season.
I think we all are.
It's part of our traditions in Calaveras in the wintertime. I was going to report out on tree mortality, but Supervisor Oliveira did it. I don't know what quite to think about another agency with the state when it sounds like the resource agency is already supposed to be doing that, but, we'll see how that goes. I did attend a couple of things that I didn't cost the county a dime, so none of these are required to be reported, but there's some of them might be interesting. I attended the public hearing for AB 142 Wild and Scenic hearing in McCalamy Hill last week, and it was really interesting. There were good questions put forward. There were good answers. It was an opportunity for people to give input. There is no piece of legislation to support or not support. It was gathering information to go into a study, and I thought it went well. I also wanted to commend many people in the community, including you, Supervisor Tofinelli, for the opening of the Veterans Hall down in Valley Springs. It was a beautiful building, and I know a lot of people in the community worked extraordinarily hard for a lot of years to make that happen, and I want to commend them all. Nice, well done. Thank you.
And I would like to commend you, Supervisor Garamendi donated a flag with his grandfather, in honor of his grandfather. It was flown over Washington to the building, and it will be flown there at the Veterans Hall. Thank you so much for that. Very nice. I did attend a couple of meetings over the course of the last couple of weeks. One was Central Sierra Child Protection Agency. That was held in Jackson. However, I did not turn in anything for recovering any funds for that, so it did not cost a dime. One other thing that I wanted to bring up was that the Angels Camp Fire Chief challenged our sheriff to the frog jump during the fair, and our sheriff accepted that challenge. I was then challenged by the mayor of Angels Camp to jump frogs at the fair. And I would like to say here that I accept the challenge, and I look forward to it, and I want to add a little bit to that challenge. I'd like to wager with the mayor. If she wins, I will buy her lunch anywhere inside the city that she would like to have. If I win, she would have to buy me lunch anywhere in the county that I'd like to eat lunch at. So a challenge to you, Amanda, coming back, and hopefully you accept it. And that's all that I have at this time. Staff? Nothing. Robin? Was it a long day? We've had longer. So, if that's it, no staff reports, we stand adjourned.